Hi, I'm Russ Wenninger. I'm a lawyer with the Wenninger John Law Firm. Today I'm going to tell you something that might be a little bit surprising coming from a wills lawyer. What I'm going to tell you is that the will isn't everything. Now, don't get me wrong, the will is an important part of estate planning. However, it's not everything. When I do wills with clients, I typically have them do two other documents, the enduring power of attorney and the personal directive. I also talk with clients about assets that they may have that fall outside the scope of the estate. In many cases, clients may benefit from doing certain things outside of their will, such as changing the way certain assets are held. If you're doing a will, you should probably also be doing an enduring power of attorney. The enduring power of attorney specifies who will make financial decisions for you if you become mentally incompetent. While it makes perfect sense to consider what will happen to your property when you die, it makes no sense at all to completely disregard the possibility that you might become mentally incompetent at some point in your life. If that happens, either due to age or due to a brain injury, for example, then you'll need someone to deal with your property on your behalf. If you're doing a will, you're doing it for your loved ones. But how will your loved ones be affected if you become mentally incompetent and no one has the legal authority to deal with your property? If you're involved in estate planning to protect your family, don't skimp on this crucial step. People are living longer and longer these days. If you live long enough, the chances are good that you'll suffer some degree of mental decline. A significant percentage of the population will be diagnosed with dementia. Be good to yourself and your family and do an enduring power of attorney while you're doing your will. The personal directive is similar to an enduring power of attorney, but instead it deals with personal and medical decisions. Having a personal directive will help ensure that you get proper care if something happens to you. This is not something to overlook. Now, this may come as a bit of a surprise, but certain classes of assets actually fall outside of the will. For example, a couple may wish to put each spouse as a joint owner of the family home. With joint ownership, if one person dies, the survivor becomes the sole owner, regardless of what is indicated in the will. If that's not what's intended, then title to the home can be changed to another type of co-ownership, which is known as tenancy in common. Also, another example, proceeds from life insurance typically fall outside of the will. For that reason, you want to make sure that the beneficiaries who are listed on an insurance policy are the people you wish to benefit from that policy. As well, if you have a business or you own property in multiple jurisdictions, even multiple provinces, for example, Alberta and BC or Alberta and Saskatchewan or something like that, you may have to engage in business succession planning or tax planning, as the case may be. Estate planning should be approached holistically. Don't just don't just deal with bits and pieces. Make sure you consider how everything fits together. If you have any questions or comments, feel free to leave them in the comment section. Thank you for watching. Bye.